Next up, we have the rise of AI in toy design, how to avoid IP claims, and how to protect creativity with Armin Ghiam. Armin?
Good morning, everyone. It's great to be here. This is my first talk at the Toy Fair. I'm excited about second time here, but the first talk. I am a partner at the law firm of Hunt and Andrews Hirth. The office is here in New York. We have offices all around the country, and we have international offices. I have worked on toy-related matters for the past decade. I have registered numerous trademarks, copyrights, patents, and I have litigated many toy cases, including the ones that I'm litigating right now. The topic of today's talk is the rise of AI in toy design. There are two components here: how to avoid IP claims and how to protect creativity. Avoiding IP claims is not getting a lawsuit. Protecting creativity is how to acquire assets such as copyrights, trademarks, and etc. So the buzzword these days is AI. Everybody's talking about AI. Every article you read talks about AI. Toy industry, like any other industries, can benefit from the advent of AI, and there are many areas that it can contribute to your work product. There are many areas. I thought of three. There could be more. These are the areas that clients have asked us about and we have advised clients on. So the easy one is creation of images, packages, and 3D objects. You can prompt any AI platform and they are going to create images for you. They're going to create packages for you. There are objects that they can create for you and you can print them and bring them to reality. The next category that I thought of, obviously the first category could be subject of copyright protection or subject of copyright claims. The second category deals with concepts and, let's say, storylines. It's more abstract. It doesn't necessarily include concrete elements, but it's a concept. It could be a toy. You could ask ChatGPT what's a good idea for a toy in 2025. Or you could ask ChatGPT for what was a good idea for a toy back in 2010 and bring back that toy. The last set of concepts and ideas that I thought about that you could get from AI is animation and games. Again, generative AI could create software for you. They can create animation, they can create characters, you name it. Well, this is good news. A lot of it is free. You give a prompt, you get a response back right away. But there are two issues that you gotta be cognizant of and you gotta be mindful of. Number one, IP ownership. If you come up with some sort of an intellectual property, who is going to own that? And the second question for you to consider is, what about infringement? Is anybody come after me? Is there anybody going to be suing me for that? So let's get a quick primer on the different types of intellectual property that pertain to toys. And I have dealt with all of these in the context of toys over the past decade. So copyrights are the easy ones. They protect expressive work. You're dealing with a photo, you're dealing with a writing. In your industry, what I have copyrighted a lot is the packages of your products. I have copyrighted the manuals, the instruction manuals. They're easily copyrighted. You could have a claim against a copycat, or you could have a claim against a knockoff. The next category are trademarks. So trademarks generally protect source designation. Essentially, a trademark tells you where a product is coming from. So very easy, brands, logos. The knockoffs try to come up with names that are similar to yours, or let's say logos that are similar to yours. And the standard here is consumer confusion. A subset of trademarks is trade dress protection, which has become incredibly popular. I have done several litigations related to toys. The white toy package guy. Everybody loves them. Everybody claims trade dress protection in them. You define some sort of, let's say, set of elements, that becomes your trade dress, and boom, you have an intellectual property for. It's a subset of trademarks. It designates a source of origin. It protects look and feel of the package a lot of times, or the look and feel of the product itself. The next category is the utility patent. So the utility patent protects functionality. Let's say you have a chair, it has 4 legs, you define them element by element. A chair with 4 legs and maybe a cushion on top of it, could it have handles? Maybe it doesn't have handles. It has to be defined element by element. There is no expression in it. The color doesn't matter. It's all about the functionality. A subset of patents is design patents. In the realm of design patents, you're trying to protect the aesthetic features of the article. It comes about in connection with some sort of a product, and it protects the aesthetic features. There is a lot of overlap with copyrights and trade dress when it comes to design patents. And the last one is trade secrets. Rarely comes up in the context of toys, but sometimes you have toys that, let's say, have chemical compounds, and you can protect them as trade secrets. All right. So when you're dealing with these types of intellectual property forms, you still have the question, you still have to clear it. If you get a prompt from an AI platform that provides you with a creative idea, a design, you still have to clear that. And let's go over them one by one. So the clearance when it comes to copyrights, the standard is access and substantial similarity. So you get a copyright claim if the person who brings the claim could show that you had access to their work and your work is substantially similar. When you get an output from an AI machine, if the result is similar to someone else's copyrighted work, you could get a claim. So it's important for you to clarify that, and it's important for you to make sure that it's clear and it's not infringing anybody else's work. The next category is trademarks. Again, you could ask AI to come up with a creative name for you. You say, hey, it's 2025, give me a creative name that nobody else is using. If you get a name out of AI, you still have to clear that. The process that we go through in a law firm is that we order a clearance search. The search is going to highlight some of the names that are in use in connection with, let's say, with toys or similar products. When we evaluate whether or not you could receive a trademark claim. Same sort of process is done for trade dress. Again, you have to run a search. It's absolutely important. It's very crucial to make sure that if you receive some sort of an output from AI, you run the clearance search on trademark and trade dress. Same also goes with patents. Utility patents, usually we hire vendors who run searches. You have to define your concept. You have to define your product element by element. You have to say what the product is, what it is that you're protecting. We run a search on it, and we come back with the results. We discuss the results with you. Simply because you get something out of AI, you're not immunized from patent infringement claims. Again, so you have to run your clearance search. The last category is trade secrets. With respect to trade secrets, in order for you to misappropriate somebody else's trade secret, well, you need to misappropriate it. You need to take it. If you receive it out of AI, presumably the information was available to the public. Presumably information was available in some fashion, in some form, so that the model was trained. For that reason, there is no misappropriation. So you should not be concerned about trade secrets when it comes to taking output out of AI. But again, it's a good idea to consult an attorney when it comes to trade secrets as well. Any questions? All right. Well, let me go back. Nobody has any questions? Any thoughts? Anybody using AI in their line of work? Yes? What do you use it for? So if you're using it, let's say, for translations, it's important to make sure that when you use the text is not a copy of somebody else's text. So you could be getting a copyright claim. Unlikely, but that's a possibility. But let's say if you have a product manual, as an example, let's say in French, and you translate it into English, and it happens that product manual was copyright protected, you could get a claim. So that's something that you should consider in your line of work. Sure, please. So that question is being litigated right now. There are several lawsuits throughout the United States, including Thomson Reuters, including New York Times. They are suing AI platforms for training their models using their articles, using their written material, using their images and whatnot. The question is being decided. I think the first lawsuit that was decided determined that in terms of AI, not generative AI, but the static type of AI they used in the context of Thomson Reuters lawsuit, that's not fair use. But that's one of the courts that has decided. There are many courts who are working on this. It's an open question right now. If you have content, it's prudent to protect your content and not make it available to everyone. Uh, but if they take your content, you can file a lawsuit. As of now, it's not nuisance to file a lawsuit. Please.
If you develop a chemical compound which is used in toys, so for that, do you need to register the trade secret? Because if you do, it's kind of out. How does it work?
You don't. So the whole essence of trade secrets is that you keep it confidential, you keep it secret, you don't share it with anyone. Even within your company, there has to be different tiers of access. Different individuals access your trade secrets. Some of them don't. People who don't need to know that, they don't access that. But in addition to that, you could also consider filing a patent application. If it's a chemical compound, if it could be, it's up to you. I mean, that's one avenue. If you want to keep it secret, you can keep your Coca-Cola flavor secret forever. There are benefits to that. If you keep it as a trade secret, it will be a trade secret forever. So long as you keep it confidential, it is a trade secret. And it has become more popular recently. The patents are not as strong as they used to be, so trade secrets is an avenue a lot of people consider, and it's cheaper. There's no cost to it. As long as you keep it confidential, it's yours. Please.
So the trade secret, it's not applicable because there is no misappropriation. Can you define that? Because I
Sure.
actually do work with companies that have trade secrets in their formulas. So we don't patent them, so they're never released. So no one else ever knows what's in it.
So the question is, let's say you put an input in AI and you receive an output. And the output is somewhat similar, let's say, to somebody else's trade secret. In order to have a claim for trade secret infringement, there has to be misappropriation. Somebody must have taken their trade secret, let's say, when it was disclosed to them confidentiality. The presumption here is that if you're receiving an output out of an AI machine, it did not hack into anybody's system. It just took what was available in the public domain. And that could not be a trade secret. So that's the idea there. So if somebody accesses your trade secret and they train their models on it, then you're in deep trouble because the public has access to your trade secret. Please.
If you're manufacturing a toy, and if it's coming from, let's say, China, then are you looking for a patent search like China and U.S.? Because they could have filed it in either one of the places.
You could file in either one of the places. Depends on where you want to have protection. Our Chinese clients have become incredibly active in this space. There are many patents that they're filing, and not just they're filing, they're also acquiring existing patents and using that on platforms, on third-party platforms, let's say like Amazon, like Wayfair. They're asserting it sometimes against other Chinese competitors, and we see that fairly often. But you could, depending on your market, if you want to protect it in the US, you file an application in the US. If you want to protect it in let's say, other countries, you file an application elsewhere. Or you could file a PCT application in the US or in China and take it to a lot of countries. These are your options. All right, let's go to the next slide. So what about the question of protection? What do we do on the question of protection? Let's say you put a prompt in AI, you get the best response ever, and you really love this response. What do you do about it? Well, not so fast. You are not going to be able to protect your AI output if there is no human involvement. So the way to do it here is to have some human contribution on some level. The Patent Office and the Trademark Office both have spoken on this issue. If there is no human contribution, that is not protectable. So the challenge is, yes, you're receiving something for free, but the thing that you receive for free is also not protectable. And your competitors could also be receiving that. So it's up to you to come up with a nuance or distinction to make it different. And some general tips for AI. Okay, number one, incredibly important, you need to have an AI policy. Your employees, well, believe me, but for the fact that I make money out of AI, maybe I had no idea what AI is. So your employees are someone who don't have to know necessarily what the implications of AI are. They see it like Google. They put in a prompt, a response comes out. It's efficient, it's fast. They don't know it. You need to have a policy. The policy has to focus on two things. Number one, on access and use at your company, number one. Number two, disclosure. Well, if you come up with some AI output, are you supposed to disclose it? Can you disclose it? Should you disclose it? These are the questions that your policy addresses that. And you have to consider that. It's incredibly important. Our clients, every one of them has one. I highly recommend it. Number two, what you put on AI is not confidential. They use your information to train their machines. So if you have the trade secret, you should not put it on AI because they use it to train their machines. It's incredibly important. Not everybody knows that. It's back in the day when Google came out and people thought Google is confidential. No, everybody has access to the input that you provide to Google, and it could be subpoenaed, and the information could be obtained. So you got to be careful in terms of what you put on AI. Number three, this is for in-house counsel. When you negotiate agreements with AI platforms, when you negotiate with any one of these platforms that are coming out, the latest and the greatest, two things to consider. Number one, indemnification. You want to make sure that in case something goes wrong, you are protected and you have indemnification. Well, not everybody gives you indemnification. It depends on your leverage. But if you represent a large enough client and it's a lot of business, they consider giving you indemnification. We have been involved in negotiations that our clients receive indemnification for use of AI. So if our clients are using AI and the output is infringing somebody else's content, they have indemnification. Number two, confidentiality. You want to make sure that the information that they're taking out of your platform, taking out of your employees, they're not using that to train their models so that the information could be leaked to your competitors and everybody else could have access to the information. So 2 points to consider when you're negotiating agreements for AI platforms. That's me. And questions?
Hi, I have a question on your slide where you were showing a few slides back that for the patent office, you now have to supply information showing that there is human content rather than just the AI. Okay, so question, 15 years ago when I was coming up with a patent, okay, real world, it used to be first to create, then it changed first to file. Now, how do I necessarily prove that AI had anything to do with it? It used to be, okay, I would come up with a concept, another toy company may, in parallel, genuinely, separately, legitimately come up with a concept, but the first one of us that filed on that concept, we did it. Now, is it my requirement to search AI to see if AI comes up with the same parallel idea that I had without using AI?
Well, in not every area of law is simple, but in terms of patent filings, fortunately in 2013, Congress passed America Invents Act. As you mentioned, under America Invents Act, it's the first to file system. So if you take output out of AI and file an application, you're the first in line. So it's recommended, if you think there is worthy material to be protected by a patent, to consider filing as soon as possible, because someone else could file. And if they file, it doesn't matter when the AI machine was trained, when the AI machine came up with it. All that matters is that filing with the patent office. Thoughts, questions? Sure.
I was going to think of an example when you were talking about the in-house counsel. Let's say I have a greeting card company. It's me. But I have an attorney that handles the business. Now a freelancer comes to me with images for my greeting cards. So you're saying I have my in-house counsel indemnify my company in case that freelancer had actually used AI to create the content?
Are you referring to the last point on my slide, or is this a separate question?
No, when you got to the point, it was the third point.
So the last point, let me go back to it. This one refers to if you're let's say negotiating an agreement with ChatGPT. If you're negotiating an agreement with, let's say, ChatGPT, you want to have the enterprise version, right? As an example, or other AIs that's co-counsel as an example. If you're negotiating an agreement with them, you want to make sure that if ChatGPT gives you output and you use the output and you get a lawsuit for that output, you are indemnified by ChatGPT. Does this make sense? Maybe I didn't explain it well. Tell me if there's a follow-up.
You're saying that you were negotiating with ChatGPT.
No. With the enterprise.
Are you using ChatGPT to write an agreement? Is that
No. What I'm saying is that let's say the company that offers ChatGPT, you want to have a license to use ChatGPT for your business. The ChatGPT that we have access to is for personal use. You want to have the business. So you talk to the company, you ask them to have a license for that. And when you get a license, in that license, make sure that you get indemnification for any output that you get. And we have 30 seconds, and I've promised them that I'm not going to go over time. So thank you so much.